Hi again, everyone. I'm attorney Robert Flesses. Over the past few years, millions of people across our country have been sued by companies like Midland Funding, LVNV Funding, and Santander Consumer USA, just to name a few. These companies attempt to collect debts that they purchased from the original creditors. When attempting to collect on the debt, these debt buyers now become debt collectors, right? Debt collectors are governed by federal law called the Fair Debt Collection Practices Act. This act prohibits debt collectors from using abusive, unfair, or deceptive practices to collect debts. Violators incur heavy fines. Well, those of you that have experienced the practices of a debt collector may have felt that they acted in violation of the act by the way they talk to you or by the language they use in the letters that they send to you. The act applies to those who are regularly engaged in the business of collecting debt as an agent of the original creditor. So the question comes down to this: when a company buys debt from original creditors, does that debt buyer company have to follow the same rules as every other debt collector? Well, you would think so, and many lower courts agreed, but there was really no clear answer on that question. So eventually, the question went all the way up to the Supremes. That's what lawyers call the U.S. Supreme Court, to decide this question once and for all. Some people that were getting abused and deceived by debt collectors started filing tons of lawsuits against debt buyer collectors all over the United States, claiming that they violated the act. The Supremes looked at the different methods used by debt buyer collectors when they contacted people. Debt buyer collectors said things like, "If you work out a payment arrangement with us, then you won't incur additional charges." Well, most people would think that meant that interest was going to accrue on the debt until it was paid. The problem is that many of these debt collectors don't have the authority to add additional charges since the original creditor closed the account. The debt buyer just bought the debt, not the original terms of the contract. Do you think that practice is deceptive? Yeah, it is. Well, then these debt buyer collectors started telling people that if their file is sent to collection attorneys, any savings on additional charges were going to be withdrawn and no longer available to them. Well, that wasn't fair either for the same reasons. So it all came down to the words used in the act to define who is a debt collector. These are the words used to define debt collectors in the act: entities that collect debts owed, or debts due, or debts due another, was part of the definition of what a debt collector was collecting. Isn't that how you would understand the debt buyer's role after they purchased a debt owed, or a debt due, or a debt due another, and tried to collect it from you? Most people, after reading a letter telling them about a debt owed, would think, "Hey, debt buyer, you're really a debt collector because you're collecting debt on a debt that is due, or a debt that was due to someone else, or a debt that's owed. You're collecting a debt." That's the definition of a debt collector, and therefore they're subject to the act and their violations are punishable by law. Well, the Supremes didn't want to interfere with the government body that wrote the law, and that's the Congress. The Supremes looked how the act was written. They applied it to certain scenarios, but refrained from amending the language in the act. They said amending the language to clarify was the duty of Congress. If there's confusion in the wording, then it's up to Congress to correct it or make it clear to everyone affected by it. So in the end, the Supremes punted and unanimously declared that a company that buys debt can collect on that debt without being subject to the violations of the Fair Debt Collection Practices Act. That's because the act doesn't apply to those who are collecting debt that they own. And it doesn't matter what tactics they use. The rules don't apply to them. Anyone contacting you to collect the debt that they own can be abusive, unfair, or deceptive to you, and that's that. Well, what do you think? Is that fair? Do you agree with that ruling? I want to hear your thoughts in the comments section below. But be nice now, no nasty words. I want to hear intelligent comments, okay? I'm attorney Robert Flessis. We'll see you in the next video, and thanks for watching.